Ohio, and ask Fred, is there any form of opening statement that the state of Ohio intends to give?
Judge, I do not intend to give an opening statement. I would just like the record to reflect that prior to beginning today, the jury trial waiver, which we discussed last week, was there was a written waiver signed by Ms. Miller, and that was filed prior to beginning our proceedings today. Thank you.
Thank you.
We do not have any opening statements. We will waive and move forward to the admissibility of exhibits. Thank you.
With that, Fred, I have in front of me what I believe are the five. One, two, three. There are the 4 paper exhibits that I have. I don't have in front of me, but they're just simply on my desk. I did not intend to bring out the videos today. But I have a collection of police reports from the Tuscarawas County Sheriff's Department, as well as there is one report, I believe, included from the Muskegon Watershed Conservancy ranger officer, correct?
Correct. There's also the coroner report.
For those reports, are you asking that all of those reports are admitted?
Yes, it's my understanding with the defense we're going to jointly move those exhibits in, stipulate to their authenticity and admissibility.
And before I hear from Ian, that would be also true then for the report from starting off from Forensic Diagnostic Center of District 9, Dr. Rinko. There is also the report from Friedman, Dr. Friedman from University Hospitals, as well as the report that was provided from the University of Cincinnati, correct?
Correct. So Dr. Rinko, Dr. Friedman, and Dr. Merritt, all 3 of those reports, I understand we will stipulate the authenticity and admissibility of those, as well as the 2 statements by Ms. Miller. One was an audio statement conducted by Captain Fisher, and the other was a video statement captured on his body work.
Ian, I'm here on states exhibits 1, 2, 3, 4, and 5.
I think the state captured it correctly. We are stipulating as was just described to you, Your Honor.
Okay, thank you. With that then, Fred, is there any further evidence that the state of Ohio would intend to present?
No, the state would rest based on those exhibits, if any.
Okay. Ian, I'll turn back to you for Ms. Miller. Any further evidence that the defense intends to present?
No, Your Honor, we rest upon the evidence which has been submitted thus far.
Okay, thank you. And the court, with those stipulations, will admit exhibits 1, 2, 3, 4, and 5. Keeping in mind, exhibit 1 has multiple parts to it. That would include all of the police reports that were provided. Based upon those stipulations, the court makes the following findings. I've had the opportunity to review all of them, and I did review all of them before I came out here on the bench today. And I'm making the following findings, including that on or about August the 23rd of 2025 in Tuscarawas County, Ohio, that Ruth R. Miller did purposely cause the death of Vincen Miller, who was under the age of 13 years of age at the time of the commission of the offense, and born on 10/12/2020, including that on or about August the 23rd of 2025, Ruth R. Miller caused the death of Vincen Miller as a proximate result of the offender committing or attempting to commit the offense of felonious assault in violation of 2903.11A1. I'm concluding that on or about August the 23rd of 2025, that Ruth R. Miller did knowingly cause serious physical harm to Vincen Miller. I'm concluding that on or about August the 23rd of 2025, that Ruth R. Miller was a parent or a child under the age of 18 years of age. She created a substantial risk to the health or safety, the case of Amber Miller by violating the duty of care, protection, or support, including that on or about August 23rd, 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Amber Miller, and their household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Joel Miller, family or household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Jordan Miller, family or household member. Now, Ruth, I've also taken into consideration not only the police reports that were provided, but I've read through all of the forensic examinations that were conducted in this case, and there were 3 of them. I think it might have been said earlier, whether it was out here or in chambers, it truly is unanimous. I ordered that a agency conduct an evaluation, forensic diagnostic 9. Your attorneys retained an individual to conduct an evaluation, and the city, all of us, had essentially our own evaluators conduct an evaluation. These are the findings that I have concluded, including that a mental status at the time of the offense evaluation was conducted by Dr. Daniel Rinko of Forensic Diagnostic Center of District 9. It was identified as a joint exhibit number 2 that has been entered into evidence. In the report by Dr. Rinko, who is a board-certified forensic psychologist practicing with Forensic Diagnostic 9, he sets forth findings in his report finds persuasive as to your state of mind at the time of the offense. Dr. Rinko opined that the defendant at the time of the offense charged did have a severe mental disease, but did not have a severe mental defect. His opinion states that as a result of the severe mental disease, the defendant did not know the wrongfulness of the act charged. And that would apply to all of the acts that is charged, not just one, but to all of them. The next evaluation that I reviewed was the evaluation of Dr. Susan Hatters Friedman of the University Hospital's Pleas Medical Center, Case Western Reserve University. It was identified as Joint Exhibit 3, and it was also entered into evidence. Dr. Hatters Friedman opined that the defendant at the time of the offense charged also had a severe mental disease, and that did not have a severe mental defect. In the report by Dr. Hatters Friedman, she sets forth against certain findings, which the court finds persuasive as to your state of mind at the time of the offense. Her opinion states that as a result of this severe mental disease, the defendant did not know the wrongfulness of the acts charged, and that would apply to all 7 counts of the indictment. Lastly, I considered the report that was submitted to me by the state of Ohio. The state of Ohio utilized Dr. Christopher Merritt of the University of Cincinnati. Dr. Merritt is a board-certified forensic psychiatrist who set forth certain findings which, again, the court finds persuasive as to the defendant's state of mind at the time of the offense. Dr. Merritt opines that the defendant at the time of the offense charged, again, has a severe mental disease, but did not have a severe mental defect. His opinion that he states is that as a result of this severe mental disease, the defendant did not know the wrongfulness of her acts as charged. Again, all 7 counts in the indictment. And while, curiously, there was maybe differences of opinion among the doctors as to what the mental disease was in this case, they all concluded that you suffered from some form of mental disease that prevented you from knowing the wrongfulness of your conduct. I would also note And I'm just going to single out Dr. Merritt. I think they all have a very, very thorough report, but I think some of these findings are worth noting as well. And that is, it's not just the three doctors who came to this conclusion that you did not recognize the wrongfulness of your acts. There are numerous witnesses who have contact with you on the days leading up to this event, that have contact with you on the day of the event, and also shortly thereafter. And to some extent, their observations and opinions here, I think, are relevant as well. Specifically singling out, though, some of the summary that was noted by Dr. Merritt. He says, Ms. Miller described in the weeks leading up to the alleged offense having shortness and erratic sleep. She described having a euphoric mood at times, which felt like she was getting married all over again. Grandiose, distractible, and at times had racing thoughts. Ms. Miller described descriptions of her belief, particularly those about tests and her expected ability reflected grandiose and delusional thinking. She ordinarily did not believe she would or had ever had the ability to walk on water, but she also believed that God had asked her to be swallowed by a fish, and she asked that her husband at one point in time to suffocate her. These reflect delusional and distorted thinking, which she did not otherwise have outside of mental health episodes. Talks about medical records supporting these same observations that you had made. He talks about eyewitnesses, law enforcement officers offering their observations that Ms. Miller's behavior was suggestive of a person experiencing an acute mental health crisis. For example, he says, Officer Katie Edwards wrote in his initial report, while speaking with Ruth, it appeared that she was not in a correct mental state. Due to this, the Rangers and I determined that Ruth needed mental health evaluation. That same type of conduct, I think, is reflected by numerous witnesses in the police reports, both leading up to the events at issue and shortly thereafter, until you receive proper care. Based upon these findings that I have made in this case, I am concluding that pursuant to Ohio Revised Code Section 2945-37, that the defendant, Ruth R. Miller, is not guilty by reason of insanity. I think that's the only conclusion that can be reached in this case based upon the evidence that's been presented to me. Ruth, after and concluding that you are not guilty by reason of insanity on all 7 counts, aggravated murder under 2903.01C, murder under 2903.02B, and D, felonious assault under 2903.11A1, endangering children, count 4, under 2919.22A, and E, domestic violence, counts 5, 6, and 7, all misdemeanors of the first degree under 2919.25A will have the conclusion that the evidence supports in this case, and that is not guilty by reason of insanity. Now that a determination has been made that you are not guilty by reason of insanity, the next step will be determining the final disposition regarding the least restrictive conditions that can be placed upon. Before I go into that, though, is there any further to state on the
Not from the statement.
Nothing further. Thank you, Your Honor.
Okay. And just confirm March the 13th? That's what we agree on?
Yes, Your Honor, just briefly though, for the court's consideration as well, we will submit today 2 additional reports for the court's review prior to the March 13th date that have already been provided to the state of Ohio, and we'll separately provide to the court via email the curriculum vitaes for both experts as they were significantly long. That'll be for Dr. Hatters Friedman and Dr. Daniel Buffington. Thank you.
Okay. One thing I don't have on that is the time.
We had it at 10 a.m.
It's at 10 a.m. All right, so what will happen, Miller, is we'll be back here on March 13th at 10. Each side will have the opportunity to present to me as to what their respective positions are regarding essentially your placement going forward. And I've heard that I know that you will be submitting that. I am afraid that you said that the state has its doctor, and I am going to reach out to District 9. I want to have their input as well as far as a recommendation. Don't be surprised, I'm guessing that they will be reaching out to you. I could be wrong on that, but I'm guessing they will have some contact with you. But I am going to Dr. Rinko to get an opinion as well. We're going to have you remanded back to the Tuscarawas County Jail. The law allows in Ohio for you to be confined during those 10 days leading up to that hearing. Is there anything further from the state?
No, Your Honor.
No, Your Honor. Thank you.
Double check my notes here. Is there anything else you need? Ordering assessment to be completed. Talked about the hearing. And the last thing is this, the findings that I made here in open court, we reduced to a judgment entry. It's a paper document reflecting what had taken place here at this bench trial today. It'll be sent to your attorneys. They can provide it to you as well as to the state of Ohio. We will reconvene in this matter otherwise on the 13th. Nothing further?
Nothing further.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah.
I'm dehydrated. Me too. I am so thirsty.
Okay.